our fellow Americans? Are we reaping our harvest of greed? Have we built our house on sinking sand? Why are we being ugly Americans?
Good morning, this is CJ Holmes, founder of Homeowners for Justice, and your host for today's show, Update Friday. And boy, do we have a lot of updates coming for you. We're going to update you on bank, watching out for them, about bank fraud. We're going to hear from Texas and North Carolina and Florida and Arizona and California. There's just a whole lot going on. A lot of it's positive, some of it's negative, and we just need to know what we're facing so that we can help each other face it better together. So before we go into bank fraud and watching out for your money, I really wanted to make an announcement. We'll do this first so I don't forget, because sometimes we run over time. And this is an announcement. Occupy fights foreclosures. I'm going to leave this up on the screen for just a minute, and of course you can go back and pause this later after the show to get this contact information. But Occupy Fights Foreclosures in downtown Los Angeles, they are very strong advocates, and they're doing a fundraiser. It's going to be I forgot to put the date. I apologize. I'm rushing so much at the last minute. Let's see. When is the date? Tomorrow, Saturday, March 30th. March 30th, Saturday, and I'll put that in the comment section. It's going to be from 6 to 10 p.m. I forgot that too. I apologize. But it's a fundraiser downtown LA at the Vortex. Here's the contact numbers. This is tomorrow night at 6 o'clock from 6 to 10 p.m. I'm sure that if you can get down there, take family, friends, neighbors, people need to understand they are victims. They are not deadbeats. Owners are not deadbeats. They are victims. And I've said this for months, for years. Don't get sad, get mad. So without further ado, I'd like to step into watch out for these banksters. This is where we're headed, and we need to pay attention to this. I'm telling you, just like the song says, I wish I could say it wasn't this bad, but better to be prepared than to be hit sideways, as we all have been.
All stations come up to mission A
oh,
for
shoot.
final
I forgot to run it and get rid of the ad.
7,
I apologize. Forget the ad. It doesn't matter.
Command is locked.
At least this one doesn't auto start, and that's the real nice thing about it. This is some news from I think it's CBS, CNBC,
The most innovative software on the planet.
they're really going to be talking about what's going on in Cyprus, and this is what we need to pay attention to, because it can happen here. Here we go.
Now let's get to the CME Group and check in with Rick Santelli and the Santelli Exchange. Hi, Rick.
Good morning, Melissa Lee. Boy, this wild ride for Cyprus is really somewhat eye-opening. Not that it's necessarily market-moving in a way that's catastrophic, but it's absolutely very important. So, let's read something that was put in the Boston Globe over the weekend, a restaurant owner in Cyprus, and let's read some of the comments that he made. I find this so fascinating. So let's put it on the screen, and this is a restaurant. He said, it's been cash only here for 3 days. The banks have been closed. We don't really know if they will reopen, and all of our suppliers are demanding cash, even the beer companies. All right, now in their own words, let's do Cyprus, Back to the Future. All right, let's start out with the following quote, and this, of course, is from the previous head of the European Commission, Jean-Claude Trichet, head of the ECB, and here's what Jean-Claude Trichet said. Jean-Claude Trichet, and I can find it, I have quite a few notes here, but what he's saying is that, you know, what's going on in the Eurozone is going to be just spectacular. They can't wait for all this to happen, and this was said back in 2008. He said that the For a small open economy like Cyprus, the European adoption provides protection from international financial turmoil. Oh my goodness, how things have changed. Now, this is the European Union Commissioner, Barroso, and here's some of the things he said going back the day Cyprus became one of the club members in the European Union sharing the euro currency. He said Cyprus has adopted a strong and stable currency, which is helping Europe to withstand global financial instability. The euro, accompanied by the right economic policies, helps create growth and jobs and keeps inflation within limits. He also went on to say Cyprus is today more than ever a proud and independent island. It has cemented its place at the heart of the EU, increased its economic potential and influence. Wow. You know, whether it's in this country, whether it's in Cyprus, whether it's in Europe in general, aren't you starting to get this vision that political leaders, Eurocrats, bureaucrats, you know, they say a lot of things, and maybe they do have the best of intentions, but just think about that store owner, that restaurateur that made the statement, you know, we have to have cash. Even the beer vendors want cash. And think back to the words that kicked this off for Cyprus. I guess what I'm getting at is as honest as it turned out to be with regard to the future of Cyprus sharing the euro, being a member of the club, let's think about how it's going to be for the next 5 years, forgetting all the issues of the Treaty of Lisbon or the European Commission, and just think about it from an economic policy about growth. We don't hear anything about that, and when we do, I think I would classify it under the same category as these words spoken in '08. They made great sound bites, they were great press conferences, but very little reality. Back to you.
Ain't that the truth? They make great sound bites and no reality. This is what we're facing. They're willing to buy in to the myth the banks sell them. They spew that garbage all over this planet. The people buy into it, and then they're screwed. And that is what's happening. We must not listen to what they're saying. We must watch what they're doing and like put earplugs in. We're not going to listen to your siren song. We are going to recognize what you're doing. And here's the next article we got to pay attention to. It can happen here. It can happen here. So one of the things that seems logical to me, and that is maybe we ought to take some money out of the bank and have some cash reserves under the mattress. Who knew? Like, I loved it. Back to the Future. Okay, let's take the money out and stick it under the mattress because it's safer there than being stolen in the bank. That's what we're facing. And I wanted to play this next little clip. It's just a minute. It's, again, William K. Black. He just so clearly states what we're facing. This is what's about. This is what it's about.
The wonderful thing about fraud is that it produces guaranteed record profits. So the person at the top sets a tone that is corrupt, and he creates financial incentive structures where if you cheat, you make a lot of money. And if you don't cheat, not only do you not make a lot of money, you get in trouble. You get in trouble in the sense that you don't get your bonus because you're not producing the income, but worse, far more powerful, you keep your peers, your friends in the organization from getting their bonus. The people who have the greatest moral backbone leave. And the folks that stay become ever more used to an environment in which cheating is the norm. Pretty soon, they almost always start joking about it. They tell these people that are prospering by cheating that they're geniuses, that they're transcendent. It's like the Ubermensch, transcends normal human morality because they're better and brighter than all of us. It's social Darwinian thought taken to the absolute max, and it degrades everything.
Exactly. Exactly. That's exactly what it does. It degrades everything. When fraud is a business model, it pushes out legitimate business. There is no way that a good business, an honest business, can maintain profits in face of other people cheating. And so when fraud is a business model, it just pushes out legitimate business. Legitimate business dies. And the people that are making the money, like he said, they take on a feeling that they're geniuses, that they're really smart, and it just corrupts everything. And literally, it's like kids. If they start to break the law, break a rule, they just ignore you and you tell them to go to their room and they don't. If you don't stop that, pretty quick they're not going to obey other stuff. And they're going to literally push the parents until there's a confrontation. That's human nature. And these bankers are no different. So what are they doing now? Since we haven't stopped them yet, they're just running willy-nilly now. They're fraudulently foreclosing. Now they're getting hired hands. Here's the article today. I want to point this out. This is how they're pushing until they completely roll over everything. So what are they doing now? They're hiring, they're hired hands, they're lobbyists to go into the legislature and change it. And this article talks about Florida. We've already talked about Washington, and both of those states are right now, the people in those states do not understand how much under attack they are. Some do. We've got activists there, obviously. We've heard from them. But you've got a few people with the millions that are in these states that are going to be steamrollered over, because what the banks are trying to do is after the fact make all of these foreclosures that they did legal. If they legalize their foreclosure theft, then there will never be any restitution. We will never be able to stop them this way. It is imperative that we get in touch with our lawmakers and get people to understand what's happening, because it's happening out of sight. It's abstract. We don't see this. If we saw somebody attacking our neighbor on the street, we'd call the police. But we don't see this insidious lobbying behind closed doors and money payoffs and agreements, and the person we elected is now no longer representing us, but they haven't told us that yet. And they're still smiling and looking us straight in the eye, and yet they're cheating us out the back door. And this is the insidiousness of it. This is why I am so dedicated to stopping this process. And if we can't stop it in the legislature, we have to stop it on the street. We have to bring their fraud to public awareness, because then people will go, wait a minute, they're cheating? What are you talking about? And then we might have some ears. So what we heard yesterday, if you were on the show yesterday, you heard Neil Garfield talk about wire transfers and how at the purchase time, when a buyer purchases the property and the bank for these toxic loans sent the money into escrow, it was not the lender. So Joe has stepped up. So I'd like to welcome Joe to the show. Just a minute here. Hey Joe, this is CJ. Welcome to the show. Hello, Joe, are you there? Joe, are you there? Just a minute. Joe?
Hello.
Hey, this is CJ. Welcome to the show.
How are you, CJ?
Oh, scrambling. How are you?
I'm all right.
So thank you for stepping up, sending us this information. I was just reminding our viewers that yesterday Neil Garfield talked about the wire transfers and how the money that came for many of these loans, most of them probably, did not come from the originating lenders, but came from someplace else. And you've volunteered and sent me some information today to help explain how that process works. I've got some documents Joe sent that that we can look at so that you can understand what to go get for your documents and order wire transfers. So Joe, I'm going to let you take it from here.
All right.
Banker men
to go
while
back to
profiting
yesterday, Neil Garfield was talking about that. Well, yes, you sign a promissory note creating a indebtedness party. That party is not always the party that produced the money, and I agree with that. So, depending on how they're going to use information, that is for the homeowner. However, what I will clarify is what a set of escrow, income, and wire transfer instructions looks like. I have an actual log that I sent you, CJ.
Yes.
And that log, it's only a paragraph. However, that paragraph is very important. What the log shows is, one, it shows the party. It shows the homeowner, or the party to whom was signing the documents for the loan. All right?
Right.
And then, secondly, it's going to show from what bank were the funds sent from.
Okay, so I've got up on the screen right now the that balance report, and I've highlighted the sending bank, which is in this case Bank of New York, and the originating party in this case was Countrywide Home Loans. And then down at the bottom I highlighted debit party, which is Bank of New York, New York.
Right, so what happens is that, again, it references their federal account number, it references the bank account information, and then where it says originating party, all right, the originating party, all right,
Yeah.
is what's highlighted in yellow, your
Yes.
second line.
Right.
It says Countrywide Home Loans.
Right.
All right. So Countrywide Home Loans, their name is on the loan documentation of the tangible promissory note.
Right.
So the wire transfer came from the Bank of New York, and it was sent to Fidelity Title National Agency. All right. So it was sent to the title company and was sent to their bank account. So even though I had contracted with Countrywide Home Loans, the money did come from a third party that was not named.
In any of the documents that you signed.
Correct.
Right.
So, again, for myself, I know that I signed a document and I have an obligation on that document. Now, yes, there are irregularities as to where the money came from, and that is what Neil Garfield was saying, and that is what this document backs it up.
Right.
It shows that the sending bank was Bank of New York, the originating party was Countrywide Home Loans, and the beneficiary bank was Fidelity National Title. So, yes, there are conflicts. I am not an attorney, and I don't, purport to be one or to give legal advice or conclusions. But again, what did the contract say is what could be disputed.
Right.
But the courts say yes, there is an obligation. So then it would just be a matter of to whom the obligation is.
Exactly, and I think that was the point from yesterday, the last 2 days, both with Charles Walshing and also Neil Garfield, and that is, okay, we're going to accept that we borrowed the money, but why would we pay this guy? We borrowed from, party A, and now party Y is trying to foreclose. So wait a minute, we want to make sure we're paying the right party.
Right. Well, again, this is just more information. Now, in order for the homeowner or the parties, the attorneys, to get the information, what they would need is just the information from the title company that they signed at closing.
Right.
And, in the documentation that they had, which is probably about anywhere from 80 to 100 pages, there's going to be a couple of documents which are closing statements.
Right. I've got one up right on the screen right now.
Okay, so when the homeowner were to call their title company, and many times I do understand that title companies are no longer in business because they have been bought out or purchased by other companies. Again, the information that you would do would be to call up your title company if it's still in business, or you would call up the title company that took over, because they are required by law to keep the records for X number of years. I'm not sure of the number of years. Neil mentioned yesterday he thought 7.
Right.
So now, the information that you would give the title company would be, 1, the date of signing, all right?
And
2, you would give them your escrow number.
right. And so it would be the escrow number, the officer, and the closing date.
Correct, and the closing date.
Yes.
Because those are very, very important. Again, it's a unique set of numbers that it identifies this is your loan.
Right.
So when we call to get our loan escrow incoming wire transfer log, we had just mentioned, 1, these are our documents, and we'd like to go over them. And I was told, well, it may take me a week to get them. They're in microfilm. Okay. So what the parties need to understand is you may have to wait a week or 2.
Right.
Again, be nice, put in your request.
Right. Did this cost you anything? Did they charge you for this?
No. And if they do give you if they do give you a hard time, you can subpoena them.
Okay.
So, again, these are your documents. Again, there is a debt. So, this is just additional information.
Right.
The whole point on educating everyone, because many times the parties that are out there, even that are with title, do not understand the requirements of law. You and I had talked earlier this morning in regards to a former bank employee that was working for 10 years in foreclosing on homeowners, and he is now working to help homeowners. So he's on the other side of the fence. However, the mentality is still out there, okay, and it's
right.
ingrained in thousands and thousands of people as to standard bank operating procedures.
Right.
In the conversation that we had, I was looking for title information regarding a foreclosure. So the gentleman had provided me the information that he is looking at a set of documents, and he sent me his report. Well, on the report it said that there was an assignment. However, into all the documents that were listed into public, it was not there. And this was a Freddie Mac loan. So he says in his report, well, Joe, there was a Freddie Mac assignment. Really? Yes, here's the date. And it was dated just within a few days of the origination of the loan signing.
Really?
So I'd asked him, well, how are you able to look at the assignment? Well, I have the collateral file in front of me. Okay, well, I know what's in the collateral file. And basically, there is an assignment listing Freddie Mac as assignee in a recordable form, but not actually recorded.
So the document was
not actually recorded because
it was in the file.
On Freddie Mac Form 10358 Revision 8, Section 3, all right, it says a determination that the assignment of the security instrument from the seller servicer to Freddie Mac is duly completed and executed and in form suitable for recording but not recorded.
Right.
So even though this gentleman had a document that was not recorded, he was looking at it as if it were a valid document.
Now, is that because that's their mentality? He actually thought it was valid just sitting in the file?
No, it is the standard operating procedure. This is their standard business practice. However, all right, standard business practice does not override the requirements of law.
Exactly.
You can go to USA versus Hibernian National Bank, all right, which says, the law is the law.
Right.
People are conditioned to believe. You know, just as I talked to a paralegal in Chicago, and he had sent me an email saying, Joe, the pooling and servicing agreement says the original mortgage note shall be endorsed by means of manual or facsimile signature in blank in the following form: paid to the order of, without recourse, with all intervening endorsements. Well, that is not an endorsement. That is an incomplete instrument.
Right.
With a stamp, with a set of specific instructions. That is order paper, paid to the order. It is not a bare document.
Right.
A bare endorsement would have a signature alone. It would have a signature. But again, this is the mentality of the people that are out there.
Right.
They've been indoctrinated into believing the sky is blue, so they think it is blue. So when the sky changes colors, they are reluctant to accept that.
Right, because this is how we do it. And how we do it must be right, because the bank told me this is how we do it.
Correct.
Lots of assumptions in there.
Right, and, you know, as James McGuire often says, you know, we do not make admissions. You know,
Right.
we state with specificity, you know, actual facts of law.
Right.
So,
Right.
even though the gentleman at Title Company had seen a document, the document was not recorded into public, and thus
Right.
not recorded and filed into public and indexed and recorded. It is not a valid document.
That's
it is
right.
just a piece of paper with writing on it.
Stuck in some file. Exactly. And he struggled with understanding that?
Correct, because he had worked for the bank for 10 years.
Right.
And he says, Joe, there is an endorsement, a blank endorsement. And I corrected him that it is not a blank endorsement.
Right. Right.
And I had sent him the statute as to what a blank endorsement is. And again, if you do not understand it, then you are just stuck into this realm of misinformation.
That's right. That's right. And they just continue that process, and as if you get sucked into it, then then you're lost too.
Right, because here, let's use California, okay? In California, 3205, which covers special endorsements, blank endorsements, all right? If we go to Section A, and A says, if an endorsement is made by the holder of an instrument, whether payable to an identified person or payable to bearer. Again, payable to an identified person or payable to bearer. And the endorsement identifies a person to whom it makes the instrument payable. It is a special endorsement. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. So, if we go to B, it says if an endorsement is made by the holder and is not a special endorsement, it is a blank endorsement.
Right.
When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession alone. C. The holder may convert a blank endorsement that consists only of a signature. Again, the magic words. Only of a signature. So it is not an incomplete stamp, all right? I mean, like they're saying, pay to the order without recourse. No, that is not blank. That is an incomplete set of instructions on order paper.
Right.
Okay, it did not say pay to the bearer. So when we look at 3205C, where it says the holder may convert a blank endorsement that consists only of a signature into a special endorsement by writing above the signature of the endorser words identifying the person to whom the instrument is made payable. I mean, hundreds of millions of transactions take place every day.
Right.
A good example is this. How many times has someone written a check? All right, everyone that's online has written hundreds or thousands of checks. And when you write your check, the check says, pay to the order of.
Right.
And let's say we're filling out this check for $1,000, and we don't fill in the payee line.
Okay.
In today's date, we write in $1,000 and we sign it. And we go to the bank and we want to cash it. All right. What does the bank say? Every single time.
Right in.
Excuse me,
Exactly.
CJ.
Exactly.
They named payee.
Right.
And you say, no, I don't want to name it. I just want to cash it. CJ, I need a named payee.
Exactly.
So now CJ writes her name in, and she hands the check back, and they say, CJ, I need your signature. All right, so now CJ signs it. And they say, CJ, I need to see your license.
Right.
CJ says, why? I need to know this is you.
Right.
It doesn't matter if you've been in front of this teller for 10 years.
Right.
It says, payable to an identified person. That party must be identified. Your license or whatever identification you use identifies you. So when a party says that the instrument shall have a blank endorsement, fine. You would write your signature, and that consists only of your signature, all right, and now you can present it. And the person holding that could cash that instrument.
Right. Right.
You know, and so right now it's just getting the information, whether it be about escrow incoming wire transfer logs, the instructions, what you've been indoctrinated to believe and what you need to believe.
So when we ask for the wire transfers, if we want to go back like you did and start from the beginning, and we contact the title company, we identify the escrow number, the officer, the closing date, and then we say we would like, what do we ask for? What is this called?
The incoming wire transfer log.
Incoming money transfer. God.
Yeah.
Okay.
Incoming wire escrow. Incoming wire transfer log.
Right. And then we should get something that looks like this that I'm showing on the screen right now. All right. Now,
that's what you would get.
So then, does this? You've been talking about, endorsing in blank or having those stamps on there without any signatures. Would there be any way to connect that information with this incoming wire transfer log?
Not that I would see. That's
okay.
Again, this is a separate issue regarding
who paid
that came in. Correct.
Right.
The endorsements that I was speaking of, that's what mortgage compliance investigators does in their analysis.
Right.
That's
right.
That's what we get into specifically, state specific, where you have to be right on the money. You have to be precise
and legal. This has to be done according to law, which now it's become very
to the requirements of the local laws of jurisdiction that you are in.
Right, and you've made it very clear that bank procedure, which many, thousands of people are now inundated with, this is just how it's done, is not necessarily legal. Doesn't necessarily follow the law, and probably doesn't.
Again, you're talking about two different things. You're talking about contracts that have been signed between parties.
Right.
All right. However, those contracts do not take precedence over the state statutory requirements. All the 50 states out there have all codified some sort of form of uniform commercial code.
Right.
Right. Whether it be New York, which uses 1961, or Louisiana, where they get into Neapolitanic. All right, each one of these states has specific recordation, specific negotiation statutes. So they're all very similar. You just need to get the exact requirements of law for your particular case. Again, everyone is different. So this is why you have to be very specific. What was done? If you are in a judicial state that has mortgages, many times a list tenants is filed and they summons, and along with the complaint, there's exhibits. Right. And with those exhibits, they usually put a copy of the note, a copy of the mortgage, and any assignments.
Now, would that be from their file? In other words, if
it would be in their court files, in their complaint.
Right, but remember how you just shared how that one situation where the assignment was in the paper file but had never been recorded.
Correct.
Would they?
And again, that's because it was a GSE.
Okay.
Because when it's with a Fannie Mae, Freddie Mac, or Ginnie Mae, those parties are not named into public. Remember, what is sold to Freddie Mac, Fannie Mae, and Ginnie Mae is a payment intangible obligation, which can be stripped legally all the time under Article 9. Okay, however, when you sell only a partial interest of the note, okay?
Yeah.
Yeah, that's all you've done. That's all you've done is just a, partial transfer of the note under, like for California, under 3203, okay? If you go into 3203A, that defines transfer of instrument and rights acquired. And then B, C, and D place restrictions upon those transfers. So when you get into 3203A, okay, where it talks about an instrument is transferred when. So we're defining the transfer. When it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to enforce the instrument. Right. Again, we're talking about rights.
Right.
There have been a number of cases out there. A couple of them off the top of my head are Kemp versus Countrywide. Linda DiMartini on page 14 of her deposition states, Countrywide sells beneficial rights. Countrywide does not sell notes.
Right.
And in the deposition of Michelle Southlander, who's
right.
president for Bank of America, she had also stated that Countrywide was in the business of selling rights.
Right.
And that is what this statute goes to. Rights acquired by transfer.
Right.
So, again, we have to be state-specific. We have to be very clear what we're talking about. When we're talking about the actual negotiable instrument, all right, then we have to get into, again, for California, it'd be 3203. If we were to look at B, again, this is a restriction. It says transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transfer to enforce the instrument,
right,
including any right as a holder in due course, but the transferee cannot acquire rights of a holder in due course by transfer, directly or indirectly, from a holder in due course, if the transferee engaged in fraud or illegality affecting the instrument. So,
right.
In this restriction, it says if there's any fraud or anything illegal, then it does not take place. And if we go down to 3203C, it says, unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement. Again, lack of endorsement by the transfer. The transferee has a specifically enforceable right to the unqualified endorsement of the transfer, but negotiation of the instrument does not occur until the endorsement is made.
Hey, Joe, I really appreciate this. We're going to have to keep moving. I would like, can you join us next week for a real focus on this endorsement transfer issue?
Sure.
I would really appreciate that.
Let me know what day,
Yeah.
and we'll just
Okay.
make it happen.
Okay. We're gonna get Joe back on the air. We got to move on and keep our
I'm
updates
sorry, I'll
going.
let you go.
That's okay, Joe. Thanks so much for sharing us with about it with this wire transfer, because that was an issue we had yesterday, and we'll be in touch with you for next week.
I will talk to you then.
Okay. Thanks a lot, Joe. Hey, Mariella, is this you?
I'm here.
Oh, thanks for joining the show, and I really asked you to just share with us what is going on in North Carolina. I know that you emailed me earlier this week. Can you just share with the group, please?
Right. I went down to the clerk's office earlier in the week to file something in one of our cases, and the door to the clerk's office was closed, and their criminal court was going on, so it was a little bit noisy at first, but then it was very quiet. So the assistant clerk's door was also closed, but she motioned us in, so I said, what's going on? I said, why is the door shut to the clerk's office? Or is she holding the hearing? And she said, yes. I said, well, in this particular case, the homeowner was being represented by an attorney, so we just let it go. But at the same time, we had a chance to sit there and talk with the clerk, and the assistant clerk, to ask her some questions. So I was asking her, just what is a contested hearing in her mind? And so what it boiled down to was if they had an attorney. I'm thinking, no, that's not quite right, because if the homeowner comes in without an attorney and she objects, she's contesting to the hearing. So, we had some really nice conversation, and I said, I don't quite understand why the clerks aren't paying more attention to the issues raised on who owns the note.
Exactly.
And she referred to a memo that they had gotten from the Office of Administration of the Courts, which basically said that MERS was fine. If MERS came in and said they owned the note, that was okay. I said, gee, can I have a copy of that memo? And she got me one.
Oh, really?
So I just want to read you a short paragraph, because the first paragraph is he's just saying, well, they're addressing the clerks of court in North Carolina, which are 100 counties, and this is their position. And he says in his memo, MERS should be treated like any other note holder seeking to foreclose in North Carolina. As such, MERS may foreclose on a deed of trust when it satisfies the requirements by presenting evidence to the clerk that is the holder of the promissory note, and then the other four things. And the questions that have arisen revolve around how the foreclosing party shows that it's the holder of the note. In determining whether MERS is the holder, the clerk should apply the same standards as we would be applied to any note holder. Now, the interesting thing about this particular memo, which absolutely blows my mind, it was dated January 24th, 2007.
Oh, my goodness.
Now,
and it's still in effect.
In 2013, we've had all these MERS cases across the country
Right.
that say just the opposite.
Exactly.
And it never was that MERS held the note anyway. They never really, they tried to claim that they owned the note, but they really didn't.
Exactly.
So I was just absolutely floored. And I said, Leanna, who's the clerk, I said, Leanna, I said, you don't have anything more recent than this? She says, no. And she went and printed me a copy of it. So we had another conversation and just talking. And she finally asked me, she said, where do we go from here? I said, well, Leanna, I will send you some court cases on MERS, and some here in North Carolina. Even though North Carolina has never had a MERS case, there are cases that talk about who owns the note and how it's supposed to be adjudicated.
Exactly.
So I did. I followed up with her, and I sent her that, and I said, as a matter of fact, in North Carolina, there is an act that was put in place, signed by the governor in 2009, that states that if there is a modification in process, she has to continue the hearing for 60 days. She didn't even know that.
Oh, my goodness.
Yeah. So I sent her a copy of that also. I'm sorry about this.
Oh, my
I'm
God.
blood boiled. And I've been, we beat our heads up against the wall with these courts and the judges and these different people involved in the process. And you wonder, where am I ever going to find a door to get in and make a difference? And it just, for days, I was just in a stupor. That
Yeah.
To think that there is so much of a war going on here, and we're fighting people we don't even know.
Well, and what we're fighting, really, I think we all need to understand, we're fighting corporate inertia. This is just the way it's done. This
Right.
everybody does it. They're just, they put blinders on and they just go down the checkbox.
Well, I'm getting to the point, CJ, where I think it's a lot more than that. I think that the bank lobbyists are so strong that
I
here you've
agree.
got the administrative office of the courts, who
Yeah.
is not an elected official.
Right.
A clerk is an elected official, and she's bound by the law. The first thing she has to do is determine who holds that note. And she skips right over it. And I'm thinking, why in the world is she skipping over the most important thing? And now I know why. Because the AOC has told her to.
Exactly. See, edicts come down from on high, and this just ties right into what we have just been talking about and bringing to people's attention, and that is, right now these lobbyists are in our legislatures trying to get bills passed
Yes.
that just steamrollers over all the laws and our rights, so that whatever they've been doing is going to be okay.
All right, let me tell you two more things now, and I know you want to move on. All right, as far as lobbyists, one of our main foreclosure mills here in North Carolina is a lobbyist in the South Carolina legislature. I have a copy of an announcement he made on his website where he had been reappointed to the Mortgage Bankers Association of the Carolinas, and then goes on to say that he's also on the committee, legislative committee for South Carolina for the Mortgage Bankers Association. That is a lobbyist. That is a huge conflict of interest, and I have already filed a complaint with the State Bar on that one.
And
but
and
going
what's
back to the AOC, so
and
I called this attorney who put out this memo, and obviously he's an older man, been there for a long time, Mr. Peter Powell, and I hope he's listening. And I had a conversation with him, and I said, Mr. Powell, I said, I'm looking at this memo that I've got, and I really wanted to ask you some questions. And we started talking about who owns the note, and we completely agreed that standing is the issue as to who owns the note.
Yes.
But then I said, okay, so we've got a memo here that said it's okay to use MERS, to foreclose in the name of MERS. If they do the assignments, everything's okay. He said, well, yeah. And I said, well, this memo was done in 2007, so why hasn't that been changed based on the new case law that's come out? He said, well, when we did this, I met with consultants, bankers, attorneys, whoever, and this is our opinion, we're still standing by it. I said, look, we've got court cases from across the country who say just the opposite. He says, well, this is our opinion, and we're not going to change it. And he says, I don't care if the case law is from any other state. We're not taking anything but what's in North Carolina.
Right.
I said, no, wait a minute. We haven't had a MERS case in North Carolina, so how can you stand on that opinion?
Right.
So the conversation got kind of rough after that, and he finally hung up on me, even though I wasn't being that bad. He did hang up on me because he didn't want to discuss it anymore, because I had just caught him in the act, is what it amounts to.
And
so
challenging.
The next step is to send him a nasty letter, give him as many fraud MERS cases as I can, and then let him stand on his premise that MERS can foreclose and be owner of the note. It's just so blatantly wrong, and you have to consider this is a conspiracy somewhere at some level that we can't get in the door. But I finally realized after thinking about this, I said, maybe this is the door I was looking for. Maybe this is the one we have to crack open, so I'm going there.
Good for
you. But
you.
I have written 3 complaints to our state bar this week, outlining some of the things that I'm seeing, and I dare them. I absolutely dare them.
Now, here's a question before you go. What is the name of that foreclosure mill that's on the legislative committee?
Rogers, Townsend, and Thompson. They have an office in Charlotte, North Carolina, but they have moved their foreclosure proceedings to the office in South Carolina to be close to Mr. Sam Waters, who is on the Mortgage Bankers Association and who is on the legislative committee to the South Carolina legislature. Mr. Waters, I hope you're listening too.
Right.
My complaint to the state bar is on its way.
See, what is happening in the way it seems to me is that we the people are finally waking up and going, wait a minute, all the vested interest against our interests already are in control.
Absolutely.
They own the legislature, they own the government, and so of course, what can we expect? So now, I really feel like we're having to try to play catch up. We have to wake up. We have to then, nudge our neighbors and say, "Hey, wait a minute! Look what's going on." And they go, "What are you talking about?
Yeah.
What's wrong with banks?"
Yeah, well, see, the biggest problem is that we're having to do a lot of this pro se.
Yeah.
And even though we have every right to do so, you got to remember. And if the attorney's listening, I'm sorry. I don't mean to put you all down because I know you're not all bad. Some of you are really good because I know one who walks on water.
I know. I know.
If we're not a part of that franchise, we got a problem.
That's right. You're either an insider or an outsider. And I have just seen that throughout real estate at every level now. Either you're insider, you're on the side of the banks, and you win, or you're not.
And you have to remember, the law belongs to the people.
Absolutely.
To the Bar Association.
I'm afraid we're going to have to really fight to take it back, though. They've been stealing it.
That's what this is all about.
Yeah.
It's a little bit of the time, and people like Neil Garfield, who, again, is one of those who walks on water in my mind.
Yes.
If it weren't for people like him, who have gotten in and dug and found a lot of stuff that he has, we wouldn't be where we are today.
That's right.
We have to have people like Neil, and we champion him and just get behind him and say, "Go Neil," and keep it up, and we learn from him. But we just have to keep chipping away, and we have to understand who we're fighting.
Exactly, and that we're in it for the long term. That's the other thing that sometimes we get discouraged over, because we see such massive destruction. I get so many emails, it's just, I can't even respond, but they just tear my heart out, because these people are losing their current life and their future. Is just flowing out, and they can't stop it, and they're frantic, and they want to know how to stop, and how do I keep my house? They've already lost their money, the economy's ruined. It's just really devastating, and I want change now. We all want change today. Yesterday would have been better. But
when you think every day,
absolutely,
houses that are being stolen every single day.
Exactly. We have to keep pushing.
Have to keep going. And still we're fighting the battle with our own clerk, who we're going to try to get her removed from office. I'll tell you that right now.
Well, there you go.
Give us a calendar of the hearing so that we can be there.
Yes.
And number one is she doesn't want us to be there. And number two is she doesn't want us to contact these people before the hearing to let them know they have defenses.
Exactly. Of course not.
And I think I mentioned this to you. Somebody, and I think it's that law firm, the foreclosure mill, Rogers Townsend, has filed a complaint with the Bar Association against me for practicing law without a license.
Why? Just because you're asking questions?
Yeah. And the first thing in their letter states, and they don't know I have the letter, says that at a particular hearing I did this, that, and the other. The problem is there never was a hearing.
Oh, my goodness.
They're just playing games. But, if they want to come talk to me and investigate me, they better be darn well willing to listen to what I got to say. Or I'm not going to talk to them, because I'm going to let them have it.
Absolutely. And boy, we really appreciate your efforts. We thank you for coming on the show today and bringing this to our attention. And truly, if you're in North Carolina or around that, Mariella can use all the support you can give her.
Absolutely. Call me. I've already had some people call me this week who are fighting in Charlotte and in Raleigh, so we're gonna get together and see what we can get done.
Perfect. Thank you so much, and keep us posted. We appreciate it.
You're welcome. Bye-bye.
Bye now. Welcome to the show. Is this Linda?
Yes, good morning.
Hey, how are you doing? We appreciate you joining us today. And there's a couple of things that you brought to my attention I asked you to share with us. First off, we're going to be talking about the Consumer Financial Protection Bureau information, and then I've asked you to share about some episode in Arizona, and then you'd brought to my attention about some attorneys, and this is one of the problems that everyone faces. If you're not fighting off a predatory, lying, toxic lender, you jump from that pan and sometimes land into the fire of a predatory, lying, toxic attorney. And many times, I just want to tell folks, with confidentiality, I'm not telling you who you are, but some of these emails that I get are very, very troubling. And I do not know enough about this to even provide an answer. And so sometimes I do forward this information to Linda, and then she will interact with me on that. And so I've asked her to share some of the things that she knows about some recent emails that I forwarded to her. We're not going to say who, but nevertheless, these are the important things. So let's start with the Consumer Financial Protection Bureau, Linda.
Yes, there's a bulletin that was published January, and I've sent you the link to that, so if you'd like to display that.
Yeah, I think I've got that.
It's called the CFPB Mortgage Industry Reforms Rulemaking and Guidance.
Yes.
And this is commentaries on the Dodd-Frank Act by compliance attorneys. And I refer to page 3, first of all, because it uses the term qualified mortgages, And it defines what these are. And this is a term that's used in the PSA, qualified mortgages. Well, it goes on to say what are not qualified mortgages on page 4. The negative AM, interest only, balloon payment, longer than 30 years, no or low documentation. All right, this goes on to go into detail. My thinking on this is like a bad drug. If it's recalled because the bond is defective, it still was defective in the beginning. So this is an admittance here that these loans were bad from the beginning. Then if we go to page 6,
and Linda, just a minute. I want
to lender's duties.
Just a sec, Linda. I want to interject. For people looking at this, I've got the highlights. What you just talked about, the negative amortization, interest only, balloon payment, a term of longer than 30 years, a no or low doc loan, or require payment of points or fees that exceed 3% of the total. Now, the fact of the matter is, I've been in this industry long enough to know that most of these were violated by virtually all of the securitized loans.
Absolutely.
Many of them were neg-am.
So the securitizations that sold the best.
Exactly.
The highest rate that the brokers could get on their yield spread.
Right. And see, everyone, when I say that these loans were designed to fail or they blew up, or what I was meaning is this is a balloon payment, and basically what they required was the monthly payment would balloon, or some of them, of course, were just short term and you had to refinance, and it would just explode. This is, or now, and this is something I just, since you've brought this to our attention, many of these loan modifications, I've seen the paperwork, and they are 40-year term. So how?
Which is now illegal.
Yeah, exactly. Oh my God. Okay, go ahead.
Okay, I'm just going to highlight certain areas that I think were pertinent to what we want to know.
Okay.
Page 6 discusses the lender's duties. Again, these are all points that we can use in our fight against foreclosure.
Right.
Page 10 is the prohibited loans. Page 11 is mortgage servicing. Page 14, borrower's right to sue servicers.
Oh, let's focus on that one.
Page. Now, I noticed in going over all this, you can come against the servicers, but it'll say the small servicers cannot be sued for these violations. Now, the reason being is that the small servicers are sub-servicers. So you want to go after the big fish, the master servicer anyhow.
Now, here's something I want to ask you. It just occurred to me because I see a whole lot of stuff and I don't have sometimes time to think through everything that zips by in my email. But someone sent me an assignment. I was looking at their documents, and after recently, it was after the notice of default, then they filed an assignment and it assigned the beneficial interest to NationStar, which is now, would NationStar be a small servicer? How do we determine what's a small servicer?
There are list publishers of the master servicers, and if she knows the trust, which should be identified in that assignment,
right,
then we can identify who the master servicer.
So here's the point, and because I have seen and been told, we've read articles that B of A, Chase, the big banks, they sold the servicing rights and the loan modification rights. That's how that's worded. Now, I've not seen that on the assignments, but that's what we're being told.
Look at page 15 on the bottom, significant servicing transfers. It mentions that, and a lot of people, when the investigation was going on by the OCC, received notification that their servicer had changed, and they thought, okay, I don't qualify for the OCC because that's not my bank anymore who's issuing the bills. But the fact is that the master servicer remains the master servicer. and all they do is subcontract it out to smaller entities. In the case of the OCC, they were doing it to try and evade any kind of liability.
Right, for the judgments and the OCC cease and desist orders, right?
Right,
Probably
but
something
it
like
says
that.
at the bottom of this page that they realized the massive amount of transfers that were happening. They don't necessarily say why, but we can put two together.
Well, and I felt from all last year, I was and still pretty concerned that the whole concept was an end run. Let's just set up another corporation, make it offshore, and we'll, it'll be wholly owned subsidiary, says the bank, and we'll just shove all of our servicing and stuff over there and get off the hook. We're gonna be, home free. And you're saying that we can still sue them, right? They won't be home free?
That's one of the issues I'm finding with the people who were not qualified for the OCC claims, because they were hiding this, and I'm proposing information to prove that they do qualify.
Oh boy. And just like Sheila Bair said yesterday, the regulators seem to be aligned with the banks, focused on the bank's best interest, rather than regulating them on behalf of the owners, the people. And so now we have to prove to the regulators that they have to regulate the bank.
Well, I think this is a very good document because it summarizes that humongous Dodd-Frank Act to what we can use in the foreclosure defense.
That's good.
I would recommend everybody get a copy of this.
Okay, I'm right now we're looking at a PDF document. I'll upload that or get the link and put it on the website so that everyone can have access to this for themselves.
Okay.
Now, Linda, why don't you share with us a quick little episode about Arizona, and then about then the attorney that I emailed you about.
Okay. First of all, I have a client in Arizona that's been fighting for 2.5 years and was making strides. He had an attorney representing him in a lawsuit because of some unfortunate circumstances. That attorney withdrew and left him high and dry. There was a trial scheduled for February, and they were in the midst of settlement negotiations with the bank, which was M&I Bank, by the way. And the client was in an auto accident and broke his back.
Oh, geez.
He had to fight very vehemently to get the court to reschedule the trial and the settlement. And there was what the bank had done had filed for summary judgment against his client, even though the trial was still in the future. So the client appeared telephonically, had a very good defense, and then we just got, that was in February. March 23rd, a ruling was just sent down, and the judge granted summary judgment. That throws out his settlement, that throws out the trial, without any consideration of what was already established, and they can kick him out any time.
I'm so sorry.
In trying to help him, I tried to contact another attorney, and this is even a worse story.
Oh, my goodness.
This attorney had begun fighting foreclosures quite vehemently, and I looked at his documents, great documents, and he was seeming to gain stride in basis of law. He personally received threats to stop, and if he continued on any foreclosure cases, he would regret it. And his wife and children were intercepted on a highway, trying to force them off the road into a crash.
Oh, geez.
This man is broken. I even called him this morning, fearing he was headed for suicide. It knocked me for a loop.
Yeah. Yeah, this is truly, death by foreclosure. And we already know that if you type that into Google, you're going to get, hundreds of thousands of links. It's just really outrageous. And another reason that motivates us to stop this horrific attack on the people. I think you told me, Linda, that some of these people have lost net worth of $20 million. Virtually the middle class is getting wiped out. Trust me, I know this. I deal with these people all the time. And ourselves, we have property It's not worth. It's everything. Everything is upside down. Are you kidding? So as the people's wealth just drains out, and the banks just keep their fraud business going on, it's truly a death sentence for the middle class in this country. This is another reason that we're fighting so hard, because if we don't fight now, if we don't stop it, it'll eventually win. There won't be anything. It's sort of like cancer. You can fight it and you can stop it and still have a life, but if you don't, it kills the organism. And we don't want to die. That is really the point. So real quick, Linda, tell me about the feedback you had on some of these emails I forwarded you.
About the documents, yeah. For some time now, I had known about, there was a group of people, I don't know if they were attorneys, they claimed that by the statements every month, you would be able to prove that the bank was taking more money from you than was in the contract.
Okay, so now we're going to just a sec. Let's call that forensic. What are those payment? When you take, so you're talking about a person that gets the loan statements, the payment statements, their mortgage statements.
Right, their monthly payment statements.
Right, and so by looking at the numbers on those statements, this group was able to discover that you were being overcharged?
Yes, and the figure was usually $20,000. And then I've spoken to a specialist in SEC and governance in Connecticut, and he supported the same thing. And then I spoke to a new neighbor that I have who's a forensic auditor for bookkeeping, a CPA.
Yes.
And he just shook his head. He said, yeah, that's probably the case. Now, the email you shared with me, they produced the IRS statement on their loan and what was paid to the IRS for taxes, and it dipped by about, $97,000 as to what they were telling the client. So they were charging the client X amount of dollars, paying to the IRS maybe only $42,000, and they were keeping the difference. And that's something we can go after immediately.
Oh my goodness. Oh my goodness. So in other words, which is the premise of my battle and statements anyway, and that is, when you let people start cheating, then they will cheat every way.
Yes.
What's going to stop them? If we don't stop them here, then they're going to cheat over there. I mean, and it's like what William K. Black said. He said, when you start with toxic loans, you just have this cloud of fraud, and it just rolls around. And so it's going to be fraudulent foreclosures and fraudulent derivatives, and and then they're going to change all the laws like they're trying to do so to make all that stuff legal and get all the regulatory people to go away. Just everybody disappear, please, and so that they can just be fraudulent and get all the money. It's mind-boggling to me. It really is, because again, how much is enough? And don't you have a heart of how you're ruining people's lives? And see, that's why Neil got out. He made it very clear yesterday. He was an investment banker. He was right in the middle of this stuff. He saw it going on, and he just didn't have the stomach for it, because it does damage lives. And anytime, I swear, anytime any company, any person seems sort of, it uses the excuse, it's just business. I frankly feel that they are trying to salve their own conscience about how horrible that went down for somebody else, and they're trying to ignore it. Oh, I don't want to think about that. It's just business. But it's not. It's not just business to the people you've just destroyed and are living now in their tents.
Well, one note, this attorney that I mentioned who was so downhearted, he said that I should spread the news and let everybody know that it's in foreclosure. It's not your fault. Exactly.
And both, I think Charles and Neil have both pointed out, most people are still in victim it's deadbeat. I'm a deadbeat. I can't pay my loan. It's my fault. I borrowed the money. They do 1, 2, 3. Borrowed the money, didn't pay, should lose the house. rather than recognize, wait a minute, I'm a victim. Yes, I borrowed money, but not from him. And now this guy's trying to foreclose on me. Wait a minute, that's not right. And it's not right. And they need to get mad instead of being sad. That's my phrase. Thanks, Linda, so much for sharing with us today. I sure appreciate it. We look forward to all the information that you bring to us so that we have these working documents and an understanding of what they say, because it really helps to be guided up front into where to look, where is that document, what does that mean, and then focus so that people can not spend all their time researching, but spending their time drafting a battle plan. Thank you so much. We look forward to working with you soon. And now I'd like to, I've asked Joy, Jerry, and Valerie if they could join us, but they're busy, but they've allowed us to share their essay. And let me get that going here for you. Sorry, it started to auto run, and that's why I got rid of it earlier.
Arrest ye merry bankermen while profiting today. You crashed the whole economy and nothing did you pay. And now you would evict us all and take our homes away. You are stealing our comfort and joy, comfort and joy. You are stealing our comfort and joy.
And we want the comfort of a home for everyone. Recently, a state attorney general said that our national economy will never function fairly and sustainably without facing and correcting the foreclosure crisis.
We agree.
The media acts like it's over as home prices are up. But only 10% of those who have lost their homes will be able to buy another home because the system is now rigged. Only those paying cash can outbid and get the house, or houses en masse. We are all being turned into renters while investors buy our houses in bulk to sell to overseas hedge funds.
Here is how California has been hit. The red parts mean 10% of the homes have been foreclosed. California is mostly red. Since 2006, the United States had 13.7 million foreclosures. Of those, 9.3 million were in the last 4 years. Just in California alone, there are 2 million underwater loans, including 16% of mortgages in Santa Cruz County, where we have about 12 homes auctioned every single day.
The ongoing fraud by the banks is truly unbelievable. Forgery, fake documents, destroyed promissory notes, intentional theft, and destruction of our property records, and ruination of our real estate market. Plus horrific financial, emotional, and physical harm to individual and family lives. I Googled foreclosure suicide and got over 2 million links.
Meanwhile, the banks get bailed out and their toxic loans are bought up by the Fed's QE3 program to the tune of 40 billion taxpayer dollars every month. And our system, from the courts to our local recorders, allows and enables their corrupt lawbreaking. Iceland, in contrast, has come up with a solution. They've thrown the bankers in jail and saved the homes of the people.
Yay!
As a result, their economy is flourishing.
This crisis, though easily unseen, lies at the heart of corporate and big money rule. When understood, it clearly demonstrates the overwhelming corruption infecting all areas of our society and how it worsens many other issues we care about: poverty, homelessness, inequality, human rights, racism, job loss, an economic system that is escalating its theft of our commons and our future.
C.J. Holmes, founder of Homeowners for Justice, calls this crisis a planned conspiracy by those financial interests to steal our homes for their own wealth. A vast transfer of wealth and power, an insider casino where they always win, and the people's pensions and funds and property and laws and communities always lose. And they can only do this because we're not watching, aware, and demanding justice.
That's why CJ Holmes has started a daily, Monday through Friday, internet TV show to educate and inform people around the country about the truth of this grand theft and what we can do about it. It's an online training and action awareness program. So our request for all of you is to get involved and check out this free and very informative program. It's a powerful way to fight corruption by educating yourself and others.
You can find this program by going to hofj.org, click on live stream on the left, then click on the live stream link on the next page and scroll down to any of the shows. Below each screen are links to articles and resources mentioned that day. This show helps homeowners, activists, and experts from around the country to coordinate and amplify their actions for change. Together, and only together, we can stop the corruption, hold banks to account, change the system, and restore our future, the rule of law, equality, democracy, and people power.
Arrest ye merry banker men while profiting today. You crashed the whole economy and nothing did you pay. And now you would evict us all and take our homes away. You are stealing our comfort and joy, comfort and joy. You are stealing our comfort and joy.
We thank you so much for that. We must stand up. We must fight back. We must coordinate. And thank you everybody for coming and watching today. Let's spread the word and let's bugger the bankers. See you next week. Oops.
When I was a lass, I was proud of me class, like my father and mother before me. They taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream, and the Labour or Liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules, and if you're one of them, bugger you, and if you're one of them, bugger you.
The system is bent and the money's all spent. We're badgered from every direction.
The workers get taxed while the wealthy relax, with nary a moment's reflection. When it's brass, there's muck, and they don't give an arse, 'cause they're programmed against insurrection. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules, and if you're one of them, bugger relent, don't give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent. By butchering women